Up next, Your Honor, is going to be Anthony McCants. Mr. McCants is present from the Summit County Jail with Attorney Paul Grant and Assistant Prosecutor Zach Neumann for the state.
This is State versus Anthony McCants, case numbers 2025-04-1231. Mr. McCants is present via video from the Summit County Jail, represented by counsel, Attorney Grant, Zach Neumann on behalf of the state.
Mr. McCants, do you agree to appear by video?
Yes, ma'am.
Mr. Grant, go ahead.
Thank you, Your Honor. On behalf of Mr. McCants, he has received a copy of his indictment and the supplemental indictment, counts 1 through 16. I've gone over those counts with him. He waives any defects in time and manner of service. He also waives the reading of his indictment in open court. He does understand the potential penalties. Your Honor, he enters a plea of not guilty for all charges, asked for a pretrial and thus to address bond.
Your Honor.
Just a moment, please.
This isn't in reference to bond, Your Honor. This is in reference to the indictment.
Oh, go ahead.
Thank you, Your Honor. The state at this time would move to dismiss counts 1 through 9 of the indictment.
And the basis for that is what?
Your Honor, we supplemented the indictment with similar charges, but included the requisite mens rea and kind of cleaned up the indictment a little bit. So it's the same exact incident, the same charges. It's just a different version of the indictment.
What was wrong with whoever went in with the original indictment, not having the correct mens rea, etc.?
Your Honor, there is some dispute within the courts and case law about whether you need to include the mens rea of recklessness for child endangering. In order to be safe, we decided to take it back in and include the language recklessness in the indictment. And we did more of a time frame as opposed to individual counts for each incident.
Gotcha. So, Mr. Grant, you entered a not guilty plea to the entirety of the indictment, which includes the direct supplement 1, which was filed on May 7th. Is that correct?
Yes.
All right. And so at this time now, Mr. Neumann indicates that you are dismissing counts. The state is dismissing counts 1 through 9, and then would be proceeding on counts 10 through 16. Correct, Mr. Neumann?
That's correct, Your Honor.
So there are some counts, I guess, that have not been replicated in the supplement from the original indictment.
That's correct, Your Honor.
So we'll make sure that everything is correct in scores as we move forward. I see we have, I'm not sure how to say your last name. Is it Attorney Bizub?
Your Honor, it's bees up. It's like bees and up. Thank
Okay.
you.
Thank you. And you are here on behalf of the alleged victims in this case, correct?
Yes, Your Honor. The alleged victim and then the deceased alleged victim's mother. Yes, Your Honor.
Thank you. And so we can be sure you filed that notice under Marcy's law. We can be sure that you get notice of all things moving forward. So now, Mr. Grant, what you mentioned something about bond. Go ahead.
Yes, Your Honor. Currently, the bond was set out of Akron Municipal Court for the original charge of child endangerment for $500,000. And that was with the understanding that there would be additional charges, and we've gone through what the new charges are now. But the court, I would like the court to consider the fact that even with these very serious charges, that my client is a young man with no criminal record, lived a law-abiding life, and has had a very, very solid upbringing in our community. The 2019 graduate of Coventry High School, then went into the Navy, had a medical discharge after that, has been involved with the community in sports, basketball refereeing, and overall just helping the kids and the youth in our community. I would ask the court to consider amending this bond to a $100,000, 10% with GPS and house arrest pending the outcome of this case. I can tell the court that the family that was living together is now not living at the same address. He can live with his father, Anthony McCants Sr., at 162 Marvin Avenue in Akron, Ohio. That I have verified that he can live there, and he will certainly obey any no contact orders the court will put in place going forward. Thank you.
Well, I do have a pretrial risk assessment. The recommendation is 500,000, 10% with pretrial supervision, etc. That is what the current bond is at this time. As those of you who work in this court frequently know, I have no understanding of the factual basis for the allegations in this case. For now, I'm going to keep the bond as it is. This says no contact with minors. I would include that. I think the prosecutor would probably want no contact with anyone associated with any of the alleged victims in this case or their family members. But we're going to leave it where it is. Mr. Grant, obviously you always have the opportunity to revisit this, the bond issue, once we get a little bit further down the road. If you want to do that, I'm open to it. Mr. Grant, what would you like your next step to be?
And if we could have a pre-trial conference with attorneys.
You want a lawyers only phone conference?
Yes, please.
Okay.
How long?
Your Honor, can we set that on an expedited basis?
Yes. We'll give it
Yes,
to you, our first
can.
available.
Mr. Neumann, you're going to be, you know what actually we're going to do? That's not true. We're going to do a video. We can have a lawyers only phone status. That's fine. But we're going to set a video status in about 3 weeks. Mr. Neumann, you're going to give me the time, speedy trial time.
Yes, Your Honor, it's June 19th.
It's what?
June 19th, as of today.
So June 19th is the speedy trial deadline.
That's correct, as of today.
Why is this case such delayed that we are unable to actually do our jobs in a fair manner to both sides? And I'm
Your
talking
Honor,
about all of us.
there was a lot of moving parts in the indictment, and with evidence, including a cell phone dump that was used. And for that reason, it took.
So all this is on the state? You think we're going to try this case by June 19th? That's what you're telling me we need to do? I could see Mr. Peacock shaking his head. Yes, we will set this. You know what? We're going to set this for trial right now. And you're going to be ready to go. We are going to set this for trial and I'm going to give you the date, and everyone's going to clear their calendars, and that's what's going to happen. We are going to start this trial on Monday, June 16th at 8:30 a.m. I will see everyone here for trial.
Your Honor, I will just let the court know the state is ready and prepared to go forward with trial on June 16th. The discovery is quite voluminous, but that's fine.
You know, here's the thing. The states clearly took all this time to push us up against this position of June 19th. And I'm not judging the reason for the time, but you took all this time. And now those choices come in to impact me. I'm sure you are ready. You've had this case for a long time. They impact the court, they impact the defense, and the ability of the defense to adequately prepare. Doesn't seem fair to me, is all I'm gonna say. But it is what it is.
Your Honor, I have not had a chance to read the medical examiner's report or coroner's report. So
When did you get those, Mr. Grant?
I just received some discovery today.
Great,
Um,
and we're going to trial because we've had all these delays and the indictment came down, didn't have the accurate elements, I guess, in it. They needed to redo it. So I hear you, Mr. Grant. Unfortunately, this is where we are. So we're set for trial on the 16th. There'll be no final pretrial.
Okay, we are concluded. Thank you.
We are concluding.
Thank you.